Hi, this is Ellen Stewart with ES Property Management, and I'm here to speak with Andrew Janutolo. He is with Goodin Abernathy. It's a law firm here in Indianapolis, and he's going to speak to us about the eviction process. He's going to tell us a little bit about two different methods, but here, let me introduce you to Andrew. Hi.
Hi, how are you?
I'm good.
Good.
Good. So you're going to speak to us a little bit today about the eviction process. You're going to talk to us about what it is when a tenant agrees to vacate the property. You either file the eviction, get the process started, and then they agree to it. And then the other one is when they don't agree to it. They fight the process. So there's two different methods there. So if you can talk to us a little bit about what an eviction is and then how those two scenarios would work.
Sure. And in Indiana, the only way to have someone leave your property is to file for an eviction. Otherwise, the tenant has the right to be on the premises, and your ability to have remedies against them is limited. So first thing that has to happen is there must be a breach, a material breach of the lease agreement. Typically, that's a non-payment of rent, but it could be other things as well.
Okay.
After a material breach of the lease agreement, you have some options. One is you can go to the tenant and you can try to work out an agreement to fix that breach. This could be letting them catch up on their rent or coming up with some other agreement to continue the relationship.
Okay.
But sometimes, as we all know, that relationship can't be saved. So the first step that has to happen is, by statute, a 10-day notice letter needs to be provided to the tenant. This 10-day notice letter needs to tell them what the breach is and tell them that they have 10 days to either vacate the premises or, in the case of non-payment of rent, pay their rent in full.
Okay, what happens if they don't pay it in full?
If they don't pay it in full, now you're eligible to file for an eviction.
Okay.
To file for an eviction, you need to go, at least in Marion County, to the township court. These are small claims, and we have several townships in Indianapolis,
Right.
to file for the eviction. That requires a filing fee. Typically, with filing fee and service in Marion County, you're going to be somewhere around $100. That number varies depending on the township
Okay.
and the type of service. Once you file that, a date will be set for an eviction hearing, and that will be a date certain that the tenant and the landlord or their representative needs to appear in front of the judge to discuss the eviction.
Who serves that notice to the eviction notice?
The 10-day letter needs to be served by someone. It doesn't really matter who, as long as the person's over 18 years old. Oftentimes the landlord, him or herself, will do that, or a property management company like yours can serve that.
We do that, right?
Yes.
And then once you've done the eviction, now how does the tenant know that they're being filed against in the eviction?
When you file for the eviction in court, the sheriff will go out to their house and serve them with
Okay.
a summons and the notice of claim.
Okay, and then when their court date will be?
That's correct.
Okay, great. So from that point in time, they now know that there's an eviction. So they can either go, oh great, and they'll call us up and say, hey, I'm being evicted, what can I do? I'll vacate, I don't want to be here anymore, that type of thing. Or they'll say, I don't agree with this.
Yes, and that's where you really get to two scenarios,
Okay.
the easy way and the hard way. The easy way oftentimes, and this is always best, to communicate with the tenant and to allow them to discuss options with you and to be a little bit flexible, because in the long run you'll probably save money that way. But if a tenant comes to you and says, I understand I haven't paid rent, can you give me until such and such a date and I'll go ahead and get out? That's fine to do, and it's fine to negotiate that way, but we need to make sure that you keep your court date on, because oftentimes tenants will lead you on in that way, but they don't actually.
Good note.
Yeah.
Good note on that.
So with that, if a tenant does voluntarily vacate the premises,
Okay.
and they've removed their property and they have, in legal terms, abandoned the premises, then a landlord or a property management company has the right to go in and to change the locks and to begin the process of documenting damages and doing necessary repairs and ultimately relisting that property for rent.
Okay.
Keeping in mind there still is an eviction hearing on the books, but what can be done at that point is, if the property has been abandoned, then a filing can be made with the court to take that hearing off or attempt to convert that into a damages hearing if the property is damaged.
Okay, great. That's a good note to make as well
Yeah.
on that. Right, then the other one is where they go, no, I'm not leaving, I don't agree with this, so.
Well, and oftentimes it's not a matter of not agreeing with it, it's just a matter of the tenant simply refusing to acknowledge the eviction proceeding against them. And when that happens, and that's fairly common, because they owe money and they typically don't have the money, which is why they didn't pay you in the first place. Typically then what happens is you'll go and appear at the eviction hearing, either yourself or by counsel or both, and you will tell the judge some basic information. You'll tell the judge, I have a lease, here's a copy of my lease, rent has not been paid for X amount of months, or there's some other material breach in the lease agreement, and you request that you get possession of that property. Oftentimes, the tenant will not even show up to these things because they don't want to be bothered and they understand that they don't really have an argument. And that's okay, as long as there's good service, the judge will still give you a date certain when the tenant must vacate the premises.
Okay, and then you have to wait until the tenant vacates the premise, and then does the sheriff do that?
Well, there's a couple of options. In a typical scenario where you go to an eviction hearing and you obtain the eviction, the judge, if the tenant is there, will oftentimes ask the tenant, when can you be out? And there'll be a little bit of a negotiation between the judge, the tenant, and the landlord. But ultimately, the judge will set a date and a time when that person needs to be out.
And how long of a time is that typically?
It can vary. It can be as little as a day or two, depending on, sometimes the tenant says, hey, I'm already almost out, give me a couple days. It can be over a weekend. I have seen in some circumstances where there's health issues or there's travel issues where up to a week or two might even be granted, but I've never seen more than that.
Right, okay.
After you get that date certain, that will go into an eviction order. The tenant still has the right to that premises until that date and time. When that date and time comes, if the tenant is out of the premises, then and they leave no property or they've abandoned any property that's in that premises, then the landlord or the property manager has the right to go in, change the locks, assess for damages, and get the place ready to be relisted.
Okay.
Occasionally, you have people who still are not out.
Right.
At that point, the process is you have to go to the court and ask for a writ for the constable. The judge will issue a writ,
Okay.
and those writs are good for 30 days in Indiana. So that means at any time during those 30 days, you can call the constable and get this particular property on his calendar. He will then make a time to go out to the property. If the tenant is still there, he will forcibly then remove the tenant and turn the premises over to the landlord or property management company.
Okay, does that include any personal belongings still in the property at that point in time, or is that a separate item?
If the constable goes out there, typically what happens is the constable removes the person and essentially removes the property as well. You're dealing with people, so there's always the chance to work something out. But typically, when a constable shows up, the person knows you're serious. And,
it's serious, yeah.
And it gets done.
Okay.
But in any event, until either they've moved out on their own, subject to the order, or the constable goes out there, you still cannot change the locks. You still cannot go in and forcibly remove them or their property at that point.
Okay. You mentioned $100 for going and starting the process. What other costs are there?
Sure. There are several costs associated with an eviction. One is simply the filing fee of somewhere around $100.
Right.
If you need an attorney to facilitate this process, and if you are a corporation or an LLC and the value of the property is more than, or the value of the claim is more than $1,500, you are required to have an attorney in small claims court. If you are a single homeowner that owns the home in your own name, you could do this yourself.
Okay.
The attorney fees in this area generally go anywhere from around $175 to $225 an hour, depending on the attorney and their experience. Flat fee payment arrangements are oftentimes made for things like this, where an attorney will do the paperwork and file the claim for a certain amount of money, typically between $100 and $200. If they're required to attend a hearing, either on an hourly basis or an additional flat fee, it's a per attorney basis that you'd have to work out.
Right.
So that's another cost associated. That cost can be recovered if
In the damages hearing?
It can be recovered in the
Okay.
damages hearing only if the lease agreement provides that attorney fees are included as a damage. If there is no attorney fee provision in the lease agreement, you're not going to be able to recover that fee.
Okay.
And then after the eviction is complete, any eviction, you will have a damages hearing set typically 30 to 45 days after the premises is vacated. This allows the landlord or the property management company to assess the damages, determine what's not reasonable and normal wear and tear, determine how much, if anything, is owed in rent and in damages beyond what the security deposit can provide. And then you'll have a hearing where you'll present that evidence to a judge and attempt to get a judgment.
Okay. All right. Well, great. Thank you so much for helping us explain the eviction process here in Indianapolis. And thank you so much for attending this. And I hope this has been informative to you. If you have any questions, please feel free to call us at ES Property Management. Thank you.